Good day to you. This week's tutorial is designed for managing agents, trustees and owners to assist all of you to become familiar with the Sectional Title Schemes Management Bill. I expect that this important bill will be approved by the National Council of Provinces and the National Assembly, read third time in the National Assembly this week. So I want to use this opportunity to familiarise you with its structure. The full text is of course in the library under the heading Pending Legislation. This bill is a major revision of sectional title management legislation. I'm going to take you through the history, the highlights, structure, breakdown and the next steps. As far as history is concerned, the process started in 2004 when Cabinet mandated an investigation into how sectional title disputes and could be best dealt with. Very soon in the process, it became clear that one couldn't concentrate only on sectional title. These were just one of a type, and so the mandate was broadened to deal with all forms of community scheme. At the same time, Cabinet made a decision that the Department of then Housing, now Human Settlements, must take over supervision of all the laws which dealt with housing, and so these two things were looked at together. A tender was awarded and work started in earnest in 2005. Initially, substantive changes were not required for the management provisions which were to be taken from the Sectional Titles Act and put into the Sectional Title Schemes Management Bill. But insofar as the Community Scheme Ombuds Service was concerned, we started with a consultation paper. All South African stakeholders were asked to comment and to give us input. And then, once we had understood and analysed that internal research, we then started on international research. Going, after looking around the world on a desktop basis, we finally went around the world really to Singapore, New South Wales and Queensland. The first drafts of the Sectional Title Schemes Management and Community Scheme Ombuds Service bills were made available in August 2005, available to our clients then, to the government. There was a bit of a hiatus then, and the process and the project was taken over by the Department of Human Settlements rather than the committee that had been dealing with it before that in 2009. And that kicked into play another second round of extensive public consultation. In 2010, the drafts went to the Chief State Law Advisor's office and then started quite a long process, started in August 2010 with the National Assembly's Portfolio Committee for Human Settlements. The Department of Human Settlements and the Portfolio Committee were the two main players in that process which lasted many months. And there were three sets of lawyers. There were ourselves as the government, the Department of Human Settlements as advisors. Then there were the lawyers from the Chief State Law Advisor's office, and there were also Parliament's own lawyers involved. After this quite extensive process, the Portfolio Committee took another trip to Queensland with the department. They talked to the people implementing the similar dispute resolution scheme in Queensland and came back with the final touches to what we were doing. In 2011, we finalised the National Assembly's Portfolio Committee process and the National Council of Provinces' various processes. Now, let's just give you the highlights. While originally the substance of the management provisions was not going to change, in the process I've described, they did in fact change quite considerably. They have been made more modern. They have been made rearranged so as to be more accessible. As I've said to you, from a practical point of view, they're accessible in Paddocks Club, but from a general point of view, it's just better laid out and therefore more accessible to people who read it. The bill is self-contained insofar as that's reasonably possible. It is much shorter. It has less than 12 pages of substance, and it has a tight focus on management. If we look at how it's actually laid out and break that down, there are 22 clauses. Only 17 are significant, as I'll explain. There are no parts or chapters. It's simply not long enough for that. But it will have to be supplemented with regulations and forms. To break it down more directly, there's a preliminary part, an extended set of definitions so that people don't have to look at any other acts at all in reading this one. Then the question of bodies corporate, how they're formed, their powers, who their members are, all that sort of thing is in clause 2 right at the start. The functions and powers, the new clauses 3 and 4, functions and powers of bodies corporate, are revisions of the Sectional Titles Act existing sections 37 and 38. Clause 5 is an addition. It draws together all the other powers of the body corporate which were scattered around the Sectional Titles Act and puts them into one tightly controlled clause. Meetings of bodies corporate in clause 6, trustees of bodies corporate in clause 7, and the fiduciary position of trustees in clause 8 have all been adjusted somewhat. Meetings is new and extensive. It takes bits and pieces from the old definitions. It's a definite improvement in my view. Clauses 9 to 13, fewer surprises. The proceedings on behalf of bodies corporate, you still have to go to the High Court for that, and the process is virtually unchanged. Rules and the variation of participation quotas, well, there are some changes in rules because now, of course, you've got the Community Scheme Ombuds Service, which is going to examine rules rather than the Deeds Office, which stopped examining rules in 1997. So there's some changes there, but expropriation of common property and the duties of owners aren't much changed. Insurance by owners has been pruned a little bit, but still substantially the same effect. Clause 15, recovery from owners of unsatisfied body corporate judgments, that is virtually the same. Appointment of administrators has been changed quite a lot. Firstly, there's more detail about the reporting obligations and the meetings, holding of meetings in schemes under administration, but the most important thing is that administrators can now be appointed and removed by magistrates as opposed to the High Court. So that's going to streamline the process of getting schemes who are in crisis dealt with. Destruction of and damage to buildings hasn't changed much, and really that's the ball game insofar as the things you've got to deal with on a day-to-day basis. Clauses 18 to 22 are the sort of thing that you'll read once, understand, and not really need to look at again much from a management perspective. This is the appointment of the Advisory Council and the way it operates, the Prime Minister's power to make regulations, the amendment of the existing acts on transitional provisions, and the short title and commencement. There have been some misconceptions. It has been said that there are 3 laws which will replace the Sectional Titles Act. Well, that's not quite right. There's now going to be the Sectional Titles Act will still be there. It will continue to regulate the registration aspects of sectional title as the survey aspects. It just won't have any management aspects in it. There's going to be a separate and new law focused exclusively on the administration and management of sectional title schemes, and that's the Sectional Title Schemes Management Bill, which this whole tutorial is centered on. And then there'll be a third bill in terms of which disputes in the sectional title industry and homeowners associations, as well as all forms of other community schemes, will be regulated. What are the next steps? Well, once the President signs it and it's promulgated, it will be a law, but it probably won't be brought into operation immediately. There still have to be regulations, and it links to the Community Scheme Ombuds Service Bill in certain regards. So the provision is that various parts of it may come into operation at different times. Those bits that require an operational Community Scheme Ombuds Service Bill will be delayed until that is the fact of the matter on the ground, and that's likely to be early 2013. Thank you very much for watching this Paddocks Club tutorial. I hope to hear from you in the discussion forum.